5 seconds to go. Start. The trial court also found that the accused appellant came out with a false plea of having gone to the other place to get medicines, though no such medicines were found in his pocket, and he failed to explain the cause of homicidal death of his wife, who was living with him prior to her death. Stop. Thus, the appellant was held guilty of the offence under section 302 IPC on the basis of the chain of circumstances proving his guilt and was awarded the punishment as noted above. Stop. The High Court also proceeded with the considerations that weighed with the trial court while further observing that when the appellant failed to offer proper explanation to the incriminating circumstances or the explanation offered by him was found to be untrue, it became an additional link to complete the chain of circumstances. Stop. Para. In challenge to the conviction, it has been essentially contended on behalf of the appellant that the consistent assertions of witnesses PW1 to PW6 that the deceased died in hospital due to illness cannot be ignored, given that they have not been declared hostile or cross-examined by the prosecution, that the inquest report was unreliable because it was not proved as to from where the dead body was brought to the police station, that the date of arrest of the appellant is questionable with reference to the overwriting in arrest memo, that the place of incident has not been proved because the site plan exhibit 3 was not enclosed with the charge sheet, that the medical evidence alone is not decisive of the matter, that non-explanation or falsity of explanation as required under section 106 of the Indian Evidence Act, 1872, cannot be a ground for conviction, and that the prosecution has failed to prove motive. Stop. On the other hand, it is contended on behalf of the respondent state that when the deceased was the wife of the appellant and they were living together, burden was heavily upon the appellant to explain the cause of unnatural death of his wife, which he had failed to discharge. Stop. It has also been contended that the appellant was absconding after the incident and was arrested 2 days later, and the plea of alibi with reference to his going to other place for purchasing medicines has not been proved. Stop. It has further been contended that the depositions of PW1 to PW6 as regards the alleged illness and hospitalization of the deceased need to be rejected because of want of corroborative evidence and then, being falsified by the inquest report drawn at the police station. Stop. Thus, according to the respondent state, the concurrent findings recorded in this case against the appellant call for no interference. Stop. Para. With reference to the outline as above and looking to the questions arising for determination in this appeal, the relevant factual and background aspects could be noticed, in brief, as follows: para. As per the prosecution case, the deceased Samina Begum was married to the appellant about 3 years prior to the date of the incident. Stop.